The next matter to come before the court this morning is Goodrich Corp. Versus PolyOne Corp. et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would wish to reserve that time, then let me know when you get started. I'm keeping the clock and can keep you apprised of the passage of time. The court's read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. My name is Claire Dickinson, and along with my partner, Lucas Blower, I'm here on behalf of the plaintiff appellant, Goodrich. Goodrich used to operate a manufacturing facility in Calvert City, Kentucky. As a result of Goodrich's operations there, it was required to respond to a number of environmental claims, and in fact, I believe entered into a consent decree involving remediation at the Calvert City site. In order to recover from its insurers the expenses that it incurred in defending claims related to Calvert City and in remediating damage, environmental damage at Calvert City, it sued a number of insurance companies who had provided it liability insurance over a long period in Summit County Common Pleas Court. It ultimately received a judgment in that action, and the action is still pending in Summit County Common Pleas in a post-judgment phase.
Counsel, before you move on,
Yes, Your Honor.
the opposing briefs indicate that there is an issue with respect to Goodrich and whether it is even a person within the state of Ohio, pointing out that it is incorporated in one state that is not Ohio. Does business, has its principal place of business in another state. How do you respond to that?
Well, as I understood their argument, it wasn't that Goodrich is not a person, but rather that it is not a citizen of Ohio. But Ohio courts are open to non-citizens of Ohio, and in fact, Goodrich was the plaintiff in the case that in front of Common Pleas Court in the insurance recovery action, and as a plaintiff in this action. Goodrich is a person, and courts are open to people. I think they were suggesting that Goodrich doesn't have a connection, but that doesn't matter. The issue on personal jurisdiction is the connection of the defendants to the state of Ohio, not the connection of the plaintiff to the state of Ohio. There was a separate action in the United States District Court in Kentucky among PolyOne, Westlake, and Goodrich. That action was ultimately resolved in a settlement, and Goodrich is part of certain parts of that settlement, not part of other parts of that settlement. PolyOne and Westlake are parties to parts of that settlement to which Goodrich is not a party. And among other things, PolyOne and Westlake agreed that if there were disputes going forward about their responsibility for environmental issues related to Calvert City, those would be resolved by an arbitration panel, GM's panel.
Could you explain that a little more?
Yeah. Yes.
Just as to how it could be a part of a party to the settlement.
Well, the settlement agreement, as I recall, specifically says that Goodrich is party to certain paragraphs and not to others. Goodrich is not a party to the paragraph involving the agreement to arbitrate. Goodrich no longer has any operations at Calvert City. Both PolyOne and Westlake do. And they're both still operating there. And so the provision for arbitration related to potential environmental claims going forward, as I understand it. PolyOne instituted an arbitration against Westlake related to alleged mercury damage at Calvert City. By the way, the insurance coverage action in Summit County Common Pleas Court, to which Goodrich is a party, doesn't have anything to do with mercury. It has to do with other chemicals. So there's this arbitration going on between PolyOne and Westlake in Kentucky, to which Goodrich is not a party. And the arbitrators have recognized that Goodrich is not a party to that arbitration, that they have no jurisdiction over Goodrich as part of that arbitration proceeding. But as part of that arbitration proceeding, Westlake requested documents from PolyOne, including documents shared with PolyOne by Goodrich in connection with the Summit County insurance coverage case within the joint defense protection. It's not really a privilege. What the joint defense doctrine is a doctrine that provides that if you share attorney-client or work product documents with another party with whom you have a joint defense interest, doing so does not waive those privileges. Did I say I want to reserve 5 minutes?
You did not, but you may if you wish.
I would like to. So, Westlake sought documents from PolyOne that include Goodrich privilege documents. And those documents are in PolyOne's possession. Goodrich instructed PolyOne not to turn them over because they are our privileged documents. Those documents are privileged under Ohio law. The arbitrators have ordered PolyOne to turn them over. That's why we instituted a lawsuit in Summit County Common Pleas seeking injunctive relief, preventing PolyOne from turning those documents over and preventing Westlake and the arbitrators from further attempting to get the documents from PolyOne.
As I understand it, there are terms in the settlement agreement that prohibit PolyOne from raising privilege or refusing to turn over documents in its possession. Is that right?
Westlake and the arbitrators have taken the position that a provision of that agreement requires them, that waive our privilege. We're not a party to that part of the agreement. Goodrich did not waive its privilege, and part of the joint defense privilege or doctrine is that one party cannot waive the privilege for another party.
But PolyOne didn't assert a privilege.
Not on behalf of itself over Goodrich's documents, because it's Goodrich's privilege is that issue concerning those documents. All of that is by way of background. The issue on the first assignment of error is whether there is personal jurisdiction over over Westlake and the arbitrators in Ohio. And our position is that there is personal jurisdiction. To begin with, the trial court made this decision based solely on documents. So all we have to do is make a prima facie showing. And so our personal jurisdiction over those out-of-state defendants is based upon the fact that that Goodrich has a right to protect its privileged documents, and they have attempted to invade that right. They have breached the duty by attempting to invade that right. They have committed a tort within Ohio because the document, PolyOne is the party with the parties. PolyOne is in Ohio. The coverage case out of which those documents grow is in Ohio. So by ordering PolyOne to turn those documents over, the arbitrators and Westlake, by requesting that order, have committed a tort within Ohio. So there is personal jurisdiction under the long-arm statute. We've at least made a prima facie showing there's personal jurisdiction under the long-arm statute, and it comports with due process.
And you're just now reaching that 5-minute mark.
I'll use one more minute, if I may. The other thing, the trial court, after determining that it did not have personal jurisdiction over Westlake, proceeded to dismiss the entire case, including our claim against PolyOne, who never even moved to dismiss. And the trial court purportedly dismissed the claim against PolyOne based upon its determination of a failure to join a necessary party. That's an affirmative defense. PolyOne never raised it, and to the extent that Westlake raised it, after the court determined it lacked personal jurisdiction, it didn't have jurisdiction to proceed to consider that question, but it dismissed based upon that. I'll reserve the balance of my time. Thank you.
Thank you.
Good morning, Your Honors. I'm Adam Noble on behalf of Westlake Chemical Corporation. A couple basic facts, I think, first, is that Mr. Dickinson's wrong about Goodrich not being a party to the contractual provision related to PolyOne's disclosure obligations. It's Section 3.4 of the settlement agreement, which is in the record. Goodrich is a party to that provision of the agreement. In that agreement, PolyOne, we had a long piece of litigation in federal court. Insurance documents were a key part of it, and the insurance information is important because the parties here are allocating costs, and whether costs have been reimbursed or insurance are critical to determining which costs are allocable or not. And so part of the settlement was, we're not going to have these fights all over again, but we are. And PolyOne has to turn over the insurance-related information in its possession and control, and it can't assert privilege over that information. And Goodrich consented to that waiver because it is a party to that section. And that's what the arbitration panel relied upon.
So we're going to find that in Section 3.4?
Yes, 3.4 of the settlement agreement, Your Honor. And then it's Section 4.2 of the settlement agreement, which specifically says Goodrich is not a party to the arbitration provisions of that agreement, and the arbitration provisions are in Section 4. So, turning back to the documents that are issued, Goodrich has never once identified the documents that it's withholding. It has just made these allegations that these documents are related to the insurance coverage and that they're exchanged in Ohio, but they've never given a privilege log. They never identified the documents. They've been asked to, and they never have. They've never identified the basis for withholding privilege, and that's frankly another reason to find, and the panel did, that Goodrich never provided an evidentiary basis for its claim of privilege. Also, it's undisputed here that Westlake Chemical has done nothing. Westlake Chemical is not the party to the arbitration. It's Westlake Vinyls Inc., which is a subsidiary of Westlake Chemical. So Westlake Vinyls Inc. is the party to the settlement agreement, and it was undisputed. PolyOne agrees in its answer that Westlake Vinyls is the party to the arbitration. Westlake Vinyls, as the trial court found, based on the submissions to an affidavit I submitted, which showed PolyOne's demand for arbitration, and it also showed an agreed order that started the arbitration. It's that Westlake Vinyls is the party involved in that arbitration, not Westlake Chemical. And Your Honors, the position here when we turn to personal jurisdiction, and by the way, we've divided up, I get 6 minutes. So I know that we had to divide it up to 15 minutes. I should have told you that. We're in an arbitration in Louisville, Kentucky, in which Westlake said, we have PolyOne, you have documents, your possession, custody, and control, which are relevant to this arbitration. And the arbitration didn't initially just deal with mercury, it dealt with ethylene dichloride, which is referred to as EDC. So you had an EDC claim, a mercury claim, and then insurance actually reimbursed some EDC claims, but we still had this outstanding issue related to mercury. And you've got the pot of insurance that we had to have an understanding of. So we moved under the contractual provisions. The arbitration panels agreed 3 times with us, and this is an arbitration in Louisville, Kentucky. And there's no dispute here that Westlake's operations have no connection with Ohio. So the only provision as far as deciding the personal jurisdiction is a long-arm statute that deals with tortious injury. And as the trial court found, there is no duty of a party litigant to refrain from seeking certain documents. There's no law that says it whatsoever. In fact, my only duty is my client to get the documents that are relevant to the claim. And so there is absolutely no tort, and there's a 3-part test as when you're talking under the long-arm statute, to where it's tortious injury committed with a purpose of injuring somebody in Ohio with the expectation that the person in Ohio is being injured. And that's where, to go to your Honor's comment, that's where our point is. Goodrich is a New York corporation with its principal place of business in North Carolina. And so clearly it's PolyOne and Westlake duking it out down in Louisville, and Goodrich just flies in. It's a New York corporation, principal place of business in North Carolina. We had no expectation, even if there was a tort, that there would be injury in Ohio. Not to mention, they've never provided any log identifying these documents. So the trial court correctly found that there is no tort. We're not following under the long-arm statute. And even if you were to find that, then you have to go to the second inquiry, which is, would it offend notions of fair play and substantial justice, whereas Westlake purposely availed itself of operating or of jurisdiction in Ohio. And it hasn't. I mean, we were in Louisville, Kentucky litigating, and Westlake never came up into Ohio. Once again, Goodrich is not an Ohio corporation. Westlake did not purposely avail itself. So then the question becomes, trial court under Rule 19, can it dismiss the whole action when it says, when it determines I don't have jurisdiction over Westlake? And also determines I don't have jurisdiction over Westlake Vinyls. There is no dispute, it has not been disputed whatsoever, that Westlake is a necessary party. Westlake's interests will be severely affected if Goodrich and PolyOne can have friendly litigation in which they just come up with an agreed order and say, okay, we're not going to turn over the documents. So in this case, we have a situation where the trial court said, what's the remedy? I know under Rule 19 that a party claiming an interest who will be prejudiced is not before me, and the court at that point in time is not required to close its eyes and say I'm helpless because another party who's hostile to Westlake will not raise this defense. The court has an obligation at that point to determine, I'm going to prejudice, if I go forward, there's prejudice to a party, that party has raised the issue before me, and it can dismiss the entire case.
And Counsel, you've utilized 6 minutes.
Thank you.
Just take your time.
Good morning, Your Honors. My name is Carol Tran, and I represent the arbitration panelists in this case. Retired Judge Gordon Dorfer from the state of Massachusetts, Mr. Eric Van Loon, also from the state of Massachusetts, and Mr. William Hartring from the state of Illinois. I adopt the facts and arguments that were set forth by co-counsel, but there are a couple of points that I would like to make with respect to the arbitration panelists. By way of context, all the parties to this case, with the exception of the arbitration panelists, have been embroiled in decades of dispute over this particular site in Kentucky. It's led to litigation, numerous litigation in Kentucky, over which the arbitration panelists had no involvement. It wasn't until 2010 that the arbitration panelists were brought in to interpret a settlement agreement that had been entered into by Goodrich, PolyOne, and Westlake, and to decide the allocation of certain costs between PolyOne and Westlake. This settlement agreement stemmed from a lawsuit in Kentucky and the settlement agreement itself was signed in Kentucky. The arbitration panelists were retained through the JAMS site, which it stands for Judicial Arbitration and Mediation Services. Judge Dorfer and Mr. Van Loon were retained through the Boston, Massachusetts sites. They were both residents and licensed to practice law in Massachusetts. And in fact, Judge Dorfer has never mediated or even arbitrated a case in Ohio. Mr. Van Loon himself, the last time he handled a case in Ohio was over 20 years ago. Mr. Hargering is based out of the Chicago, Illinois JAMS office, and he's also a resident of Illinois, licensed to practice in Illinois. In the past 5 years, he's handled over 210 cases, only 6 of which had any relation to the state of Ohio. When they were called in to arbitrate this case, their expectation was that it would be handled in Kentucky. It was involving a settlement agreement in Kentucky concerning environmental site in Kentucky. At that time, they had no idea that Ohio was even in the picture. To determine personal jurisdiction, the court has to look at first the long-arm statute and the corresponding civil rule, and then next look at the due process clause of the 14th Amendment. But the scope of the long-arm statute is actually more narrow than the due process clause, so if you don't satisfy the long-arm statute, there's no need to proceed to the due process clause. Goodrich has alleged that the arbitration panelists have somehow caused a tortious injury in Ohio. The fact is there hasn't been any tort in this case. And Goodrich has not cited a single Ohio case that states that a discovery dispute or disagreement with the discovery order gives rise to a tort. And in fact, if every dissatisfied party to a discovery order had an action in tort, practically every litigation would lead to another litigation. One other point I'd like to add is that the arbitration panelists are not a proper party to this lawsuit. While I recognize that the narrow issue before the court today is one of personal jurisdiction, the broader fact that all the parties are here in court fighting about a discovery order that was issued in an arbitration completely defeats the entire purpose of alternative dispute resolution, which is to keep the parties out of court. By bringing the arbitration panelists into this case, Goodrich has essentially asked the judge to look over the shoulders of arbitrators, mediators, and to supplant their judgment for the judgment of arbitrators who are attempting to resolve these issues outside of court. So I request that the court affirm the trial court's decision and find that Ohio lacks personal jurisdiction over the arbitration panelists. Thank you.
Morning, Your Honors, Brandon Moore. On behalf of County PolyOne, may it please the court. Our position in this case is a simple one. Our role here has been limited. I'd just like to reiterate that PolyOne takes no position on the substantive or jurisdictional questions before the court. PolyOne does not take a position on Goodrich's claims of privilege, and the case is simply that PolyOne finds itself trapped between the conflicting demands of PolyOne's requests and the arbitral panel's orders that the documents that Goodrich claims to be privileged should be produced. I'm here before you today because PolyOne merely supports a resolution of this matter by a court of competent jurisdiction. That's it. Thank you.
Wanted to, if I misspoke and said that Goodrich is not a party to section 3.4. I apologize for that. It is a party to that section. It is not a party to the section that calls for arbitration. And when you look at section 3.4, you will see that PolyOne specifically waived privilege. Goodrich did not in section 3.4. Mr. Goebel said that the arbitration originally involved TCE. It did at the outset. That claim was long gone from that arbitration before this issue arose. At that point, it only involved Mercury, and by the way, was stayed even regarding that. The only thing the arbitration panel was doing was assisting Westlake in its attempts to get Goodrich's documents.
What of the claim that Goodrich has never identified the documents that it claims are privileged?
That's because the arbitration panel has no jurisdiction over Goodrich. We're not going to submit to its jurisdiction and have it determine whether our documents are privileged. We'll be happy to have a trial court in Ohio. We'll be happy to submit a privilege log to a court that has jurisdiction over us and the parties. The arbitration panel...
It sounds like you want it both ways. On the one hand, the arbitration panel had no jurisdiction, but they allowed you to come in and argue these issues.
They did allow us to come in, and we argued that they did not have jurisdiction. When that agreement is reviewed, you'll see we did not agree to arbitration. And Ms. Tran's argument about judicial immunity and so forth, they are not our arbitrators. We never agreed to them deciding any issues involving us. And even if we were to compare it to a situation, let's say a trial court in Ohio exceeded its jurisdiction, there could be an original action filed against that trial court to have what it did outside its jurisdiction declared void. So immunity is just a red herring in this case. The arbitrators in relationship to Goodrich are three private individuals who are purporting to order PolyOne to turn over Goodrich's documents. We have a right to have our right to keep those documents privileged decided by a court in the state of Ohio. The privilege is given by Ohio law. And if we can't do it here, we don't have Westlake took us through a journey of federal district courts, first removing to the federal district court for the Northern District of Ohio, who sent it to Kentucky, who determined that it did not have jurisdiction over this case. And that's why we're back in Summit County Common Pleas Court where it belongs. Thank you.
Thank you.
Thank you.
Thank you. Thank you all for your presentations this morning. The court will take a matter of advisement, issue a written decision, which will be mailed to all sides, as well as posted on the Ohio Supreme Court website, which you can link to through the 9th District Court of Appeals website. Thank you all.